All right, morning everybody. Can you hear me in the main jail? Not? Okay. Okay, all right.
Good morning, Your Honor. Main jail here.
Morning.
Are you on probation for anything? I don't find a pretrial.
I am. Nancy.
For domestic, right?
For domestic, Your Honor, yes. Nancy Morales, Your Honor.
Okay, that's the name of the defendant?
Yes, Your Honor, page 1.
All right, that's my first case, actually.
All right. May I call it, Your Honor?
We'll have to wait for the,
No problem.
for the attorney in the jail to...
She's private. She's not represented by the public defender's office.
Okay,
So we can start with her.
all right.
We get, just let them know that we were
All right, how about, let me just start by saying my name is Judge Kathleen McHugh. I'm the judge presiding over the magistrate hearings this morning. I've reviewed everybody's probable cause affidavits, and I'm going to determine whether or not there's probable cause to hold you, and then set the appropriate bond amount. All right, let's begin with Nancy Morales. All right, morning, ma'am.
She's talking to you.
Please state your name for the record.
Good morning, Your Honor. Sasha Bertiger on behalf of Miss Nancy Morales, Your Honor.
Okay. All right, ma'am, you're charged with 1 count of aggravated battery with a deadly weapon, domestic violence. I do find probable cause to detain you. Does the defendant have any prior criminal history?
No, Your Honor, just infractions.
Okay. All right, what would you like to say?
I was going to request a $5,000 bond, Your Honor, on the matter. She has no prior criminal history, Your Honor. She's not at risk of flight. She has substantial ties to the community. There's 3 children in common that she has with the husband that's the alleged victim in this case, Your Honor. I do have an alternate address for her to reside at as well that I can provide the court.
Set bond in the amount of $5,000. No contact, directly or indirectly, with the listed victim. If you're in possession of any firearms or ammunition, they need to be surrendered to your local police department.
Thank you, Your Honor.
Okay, thank you.
Have a good day.
Okay.
I'm sorry? You're going to stay with her.
we could go through the docket. If I could just have a moment.
All right, that's fine.
I'm straightening them.
Okay. All right, that's fine. All right, Jerian Fox. All right, morning. You're here for 1 count of violation of an injunction against repeat dating violence. I do find probable cause to detain you. Does the defendant have any prior criminal history?
I see it 2011, strong arm robbery, Your Honor.
Okay, counsel?
Sir, do you have a place to stay separate and apart from your grandmother?
No,
Okay. Who's going to help bond you out?
my mom.
Can you stay with your mom?
Yeah.
Women.
Yeah.
Okay.
Women.
What address would you be staying at?
I was staying with my grandma.
Miss Lazo?
You got anybody else you can stay with?
Yeah.
Okay. And who would that be?
Baby's mother.
What's her address?
I don't know it, but I can get it for you.
Are you working?
No.
Are you in school?
No.
Do you have family down here? Is all your family down here?
Yes.
And have you been living in South Florida all your life?
Yes.
By yourself?
Judge, he does seem to have ties to the community. I would ask the court to set a reasonable bond. I just noted just 1 prior.
All right, sir, I'm going to set bond in the amount of $1,000. No contact directly or indirectly with the listed victim. If you're in the possession of any firearms or ammunition, they need to be surrendered to your local police department.
Okay.
Good luck to you, sir. Anderson,
You too.
Andrew.
I'm sorry?
Thomas Heath.
Yep.
1 count of touch or strike battery. I do find probable cause to detain you.
Our signs are already there. Circle these notes, these notes, these notes.
Do you have a place to stay separate and apart from the victim in the case?
Yes,
Yes, I do.
Are you currently working?
Yes, I am.
What do you do?
I work at the Georgia Pig Restaurant in the kitchen.
Okay. How long you been living in South Florida?
35 years.
Okay. Do you have family down here?
Yes, I do.
Do you have money in the bank?
Yes.
How much bond can you afford?
I don't know, $100.
Okay. Who's going to help bond you out?
I'll have to have my mom get money out of my account.
Okay. Judge, I would ask the court to set a reasonable bond. He said he is gainfully employed. He does have ties to the community. His mom resides here. She's going to help him bond him out. I didn't hear anything in regards to his priors. No, Judge, would the court consider releasing him on his own recognizance? He does have a place to stay separate and apart from the victim in the
Okay,
case.
sir, since this is your first time ever in trouble, I'm going to ROR you. No contact directly or indirectly with the listed victim. If you're in the possession of any firearms or ammunition, they need to be surrendered to your local police department.
Okay.
Errol Watson.
North Broward.
Errol Watson.
Here.
He's in North Broward.
That's what I'm looking at. Going once.
Yeah.
My only concern with the Watson case was the proof of service.
Okay. All right, let's pass Mr. Watson's case. We'll come back.
And did I reopen for
Joan
We have
San Pedro Ortega.
Who said I reopened?
Kieran, can we put this on recall? He needs a translator.
All right, Spanish interpreter.
Yes, Your Honor.
I called the left one message.
Okay. Thank you.
All right, Gregory Robinson.
North Broward.
All right, Mr. Robinson, you're here for 3 counts. Count 1 is a robbery by sudden snatching. Count 2 is criminal mischief. Count 3 is resisting without violence. I do find probable cause to detain you. Does the defendant have any priors?
I've seen it all up, petty theft 2008, trespass 2005.
All right, sir, I'm going to set bond. Or does the defense have anything you want to ask?
Your Honor, additionally, he was adjudicated on the battery charge in 2005 as well.
Okay.
Judge, the last known conviction for anything considered a crime of violence was in 2005. Do you have a place? Do you have a stable residence, sir? Do you have a place where you can stay?
No.
That's why. No, don't talk about what happened that day. Do you got family down here? Anybody to help bond you out, sir?
No. Maybe my mom.
Where's your mom stay?
And Daniel.
And Dania? Can you call her
Yeah.
and see if she can help you bond out? Judge, I would ask the court to see a reasonable bond in the case.
Sir, I'm going to set your bond in the amount of $2,000. On count 2, it's set at $500, and on count 3, it's $100.
All right, let's go.
All right, the other case at North Broward was Errol Watson. Is he there now?
Yeah, he's a medical reset again,
Okay.
Your Honor.
All right, thank you. Robert Bryan.
Main jail.
Okay. All right, you're here for a domestic battery by strangulation. I do find probable cause. Does the defendant have any prior criminal history?
He has a 97 driving while license suspended. He has 2 counts of battery from 2010 that he was adjudicated on. And he has a possession of an undersized grouper from 2012 adjudication.
Can And Your Honor, in speaking with Mr. Bryan, he's been here for the last 25 years. He currently has 5 children. He does construction for work. He believes that his family can probably afford a $1,000 bond. And if released and there's ordered no contact with the victim, he can live with a friend.
Okay. I've heard several violent priors in the past, so I'm going to set bond in the amount of $10,000. No contact directly or indirectly with the listed victim. If you're in the possession of any firearms or ammunition, they need to be surrendered to your local police department. Randolph Price. All right, so you're here for 3 counts. Count 1 is touch or strike battery, domestic violence. Count 2 is in possession of cocaine, and then you have a capias on a traffic charge, for which the bond has been set for $250. If you find probable cause, as to the possession of cocaine, I find probable cause, bond set at $1,000. Defendant have any priors?
Your Honor, just for the record, the defendant declined the services of the public defender's office.
Okay. All right, does he have priors?
2010 possession of cannabis, 2008 possession of cannabis, 2003 possession of drug paraphernalia of marijuana, 95 possession of cannabis, 91 carried concealed weapon.
That's it? That's everything?
Yeah.
All right. Set bond on count 1 in the amount of $2,000. No contact directly or indirectly with the listed victim. If you're in the possession of any firearms or ammunition, they need to be surrendered to your local police department. Jason Griffin.
Conti, Your Honor.
All right, Mr. Griffin, you're here for a capias on a felony, violation of an injunction for protection against domestic violence. You're being held no bond. Is he entitled to bond?
Is it not in custody cases? Okay.
Why is it a no bond? I don't see that it's a failure to appear.
It seems like an ad charge. He would be into. It may be. He's entitled to a bond if it's an ad charge. And it seems like it's a count 7. Unless it's a failure to appear, but I have no information that it's a failure to appear. It seems like he's been sitting in custody.
Doesn't appear to be an ad charge, like a 7 charge. He's got 7 charges pending. All right. Does the defendant have any prior criminal history?
One second, Judge.
What was his original bond?
Court to set a reasonable bond on this case. He has.
Aggravated stalking, because it's showing a violation of an injunction for protection against domestic violence, which is a misdemeanor, but then it says capias on a felony.
That's for the
And they add charge to violation of injunction.
Okay. So he's entitled to a bond on both counts.
He's entitled to the bond.
Yeah.
All right.
Sir, were you working prior to your incarceration?
Yes.
What kind of work do you do?
Concrete construction.
You got a place to stay separate and apart from this from the victim in the case?
Yes.
He had the original bonds before was on the other count was $50,000 on each count. Pre-trial with the GPS.
Well, it seems like it's a change of charge, right? An ad charge.
Maybe it was ag stalking and they downfiled it.
They downfiled it to a violation of injunction, so I would ask the court to lower the bond. How long you been in South Florida?
Since I was 16 years old.
Okay. You have family down here?
Yeah.
Okay. Do you have money in the bank? I mean, how much could you or your family afford?
Count one is ag stocking.
Probably cash out bond, a couple of 3,000 tops, maybe.
Judge, I would ask the court to set the bond around $2,000. It went from an aggravated stalking to.
Sure it was an ag stalking initially?
That's what this for Mr. Griffin. Yeah.
It was originally an ag stalking?
It was.
Count one was.
I thought it was an ag stalking change of charge to violation. No. Okay.
The ag charge, they're not charging.
Are you looking at the count 4 is the ad charge? Count 1 was change of charge from possession of weapon or ammunition, violent career criminal, and it was change of charge to firearm by felon.
Oh, what's count?
Count 7 is what we're carrying. Count 7 is just a violation of domestic first degree misdemeanor. It was ad charge by the state.
All right, now why does it say KP as felony? Is that just put in there again
It's part of the same.
correctly? Because the violation of justice is not a felony.
Your Honor, I believe it says KP as felony because
Does he have a
the
bond
other
on the
charges
firearm
are
for
also
felon?
a felony.
It's
And
under
this
felony
is
case.
yes,
It
this
started
is just
out
added on
as
to that one.
Gotcha.
Count 1, possession of weapon,
50,000,
his bond,
Yeah.
is
and then they made it no bond.
All right.
Count 2 was
He needs it.
ROI. Count 3 was no info as well as count 4. He has a bond on count 5 of $10,000. He has a no bond violation of probation on his felony DUI, no bond.
All right.
So this is where.
Well, Judge, the count one and the ad charge, he's entitled to a bond. I understand he's being because they changed it from firearm violent career criminal to firearm by felon, so it went from a 250. It's an academic issue, but
We're only handling count 7 at this point. So I'm going to set bond in the amount of $2,000. No contact directly or indirectly with the listed victim. If you're in the possession of any firearms or ammunition, they need to be surrendered to your local police department. Nicholas Cipriano.
Paul Ryan, Your Honor.
All right, Mr. Cipriano, you're here for an aggravated stalking after an injunction for protection.
I went to arraignment for this yesterday, ma'am. I was arraigned and given a bond.
How much, is that true? What's the bond amount?
50,000.
be said from yesterday. What was your bond? Who was your judge? And
I went to Judge Cohen. I was given a total for both charges, $75,000, which is a bit exorbitant. I can't afford to pay it, and I have to go to work, and my girlfriend is pregnant at home, so I can support our home.
yeah, he has a
All
bond.
right, so how much would this bond set?
The judge set it at 25,000 on this count.
Okay.
The state would be asking for 50,000.
It was already set yesterday.
Yesterday?
Yeah, 25 you said?
Yes.
Okay.
Can we reduce that bond?
Now you're gonna go and have to go in front of Judge Cohen.
All right.
Yeah.
Your Honor, you're next.
Already said.
Step away. Good. Have a seat.
Roberto Viana.
Paul Ryan, Your Honor.
All right, sir, you're here for an aggravated assault with a deadly weapon and also a second count of burglary of a dwelling, structure, or conveyance. I do find probable cause. Is this defendant entitled to a bond?
They set the bond here. He may have signed a KPS. It seems that it was a change of charge, so there may have probable cause was already found.
Okay.
I think this court is only to determine the bond, but I can't. All candidate court, I can't tell from the docket. It says burglary, dwelling, structure, or conveyance, and on the booking sheet it says burg, dwelling, structure, or conveyance,
I don't
armed.
have any police reports or anything to give me any information about where the bond should be set.
Your Honor, I see that the state filed information on this particular gentleman. Count 1, it says armed burglary. Count 2 said aggravated assault with a deadly weapon. And count 3 said ag stalking. I know when he was initially magistrated, or currently at magistrated, evidence and presumption of rape on Mr. Piano and held him no bond
All right.
on one of those. So
All right.
I know he's only here for 1 and 3 today.
Sir, are you represented by an attorney?
Yeah, Mr. Michael Weinstein.
Michael Weinstein's your lawyer?
Yeah, yeah.
Oh, this was filed yesterday?
No, I mean last week.
You're gonna have to contact him in order to modify your bond conditions, because currently you're being held no bond.
Both charges?
Contact your lawyer.
All right,
Okay.
sir, I'm gonna, if you have 2 no bond holds, you're gonna have to go in front of Judge Cohen in order to have your bond set, or...
He has a court date, 6/25.
All right, June 25th in front of Judge Cohen. Here's your information back.
That's it?
Deputy McBride, 88.
Olga, cool.
North Broward.
All right, you're here for driving while license suspended or revoked, and also disobeying a red light. I do find probable cause. Bond has been set in the amount of $25.
Okay. Can I bond myself out?
Yes, you can.
Okay. Thank you.
You're welcome. Sarah Rodriguez.
North Broward.
Yes, ma'am.
Okay, ma'am, you're here for a touch or strike battery and also a disorderly conduct. I do find probable cause. Bond has been set in the amount of $1,000.
Ma'am, my brother's in hospice, and I don't have anyone that can come. Can I please be ROR'd, ma'am?
Does she have priors?
Yes, I do. There's a video. I didn't see it wasn't, I'm not guilty,
Ma'am,
but please.
just wait 1 minute. I'm listening to what your prior record is.
It's bad.
2012. 2010 prostitution with a controlled substance. 2010 trespass.
I don't have a violent record.
All right, you're gonna have to post a bond, ma'am. Your bond's been set in the amount of $1,000. Next case, Alexandra Negron.
Paul Ryan, Your Honor.
All right.
Good morning.
You're here for trespassing unoccupied structure or conveyance, and the KPS on a misdemeanor charge. I do find probable cause. Bond has been set in the amount of $25 on the first count and $500 on the second count. Your next court
I don't
date is set
understand.
for June 22nd at 1:30.
I can't hear. I can't hear. I couldn't hear you.
All right, I'm here for trespassing and a KPS on a misdemeanor charge. I find probable cause. Bond is set in the amount of a total of $525. Your next court date is June 22nd at 1:30.
Okay, I don't understand how there's two. It should be, the KPS is the trespass charge.
No, that's separate.
How is it separate? All right,
Okay.
thank you.
Thank you.
It's separate.
Jessica Harrison. All right,
North
you're
Broward.
here for one out of county's hold on a misdemeanor charge and an out of state hold on a felony. You have a bond on the first charge amount of $9,999 and a no bond hold on the second out of state hold.
Otto. Yeah. You can't be an auto. Are you done?
Amanda Smith.
Smith.
Oh, it's blurry. What happened?
North Broward is for Smith, Your Honor.
All right. Okay. All right. You're here for possession of cannabis, 20 grams or less, a violation of probation on a felony, and a probation violation or community control violation on a felony charge. Being held no bond on the violations of probation. I do find probable cause as to the cannabis. Your bond's been set in the amount of $100 on that count. Your VOP hearing is June 16th at 8:30.
Got it? Let's go back.
Lillian Lazo. Lillian Lazo, you're here for
Thank you.
DUI alcohol drug, second offense. DUI unlawful blood alcohol content .15 or greater. Fleeing and eluding. Driving while license suspended, first offense. If you find probable cause, your bond on counts 1 and 2 are $1,000. Does the defendant have any prior criminal history?
Yes, Your Honor, the second DUI was on March of last year for DUI, and the prior, Your Honor.
Hold on.
I think we have some family members here.
Oh,
Yes.
Sorry, can you go ahead and state your name for the record?
My name Lilian, Maria Lilian Lazo.
Okay, what's your relationship to Lillian?
She is great. She is.
What's your
Yes,
relationship to Lillian?
This is my daughter.
Okay.
Yes, it's a great to me in the house. Everything is great. She is having a problems. I need the help con the medicos for she is having I needing a help you. What's this?
Her mom wants her to get help for. We think she's an alcoholic and she needs help for counseling for depression.
Yeah, she's having a lot of depression. She's divorced the husband. She got a depression. I need to help you.
All right, and she's currently on probation for a DUI, right?
Yeah, yes.
All right.
Should.
All right, the state have a recommendation for setting bond on the fleeing or eluding.
They would request $5,000.
And Your Honor, I'm asking if the court will consider setting a $1,000 bond. She's been here all of her life. She's a U.S. citizen. She does have 2 children. She does maintain a job at the Little Rescue Academy. And she's indicating that she believes her family is able to afford somewhere around $200 or $300.
All right, I'm going to set bond on count 3 in the amount of $500. Standard pretrial release, and I want her fitted with a TAD device. She's to have a substance abuse evaluation within 15 days of her release. Follow any recommendations of that evaluation. So her total bond amount is $2,500. She's also on probation when she picked up these charges. So I'm going to let probation take its course. They're most likely going to send a warrant to the judge, and then she's going to be probably back in custody for a violation of probation.
Mm-hmm.
All right? All right, so her total bond amount is $2,500 right now. When and if she's released, if you do bond her out, she's going to be on a device that's going to monitor her alcohol level if she were to drink.
Yeah.
And, pretrial will be alerted and she'll go back into custody.
Okay. Okay.
All right, thank you.
Thank you, ma'am.
Thank you.
Elwira Strezlik. Okay, you're here for a violation of probation on a felony charge. You're being held no bond. Your next court date is June 16th at 8:30. Melissa Morales Rosa. All right, you're here for a aggravated battery on a person over the age of 65. Does the defendant have any priors?
She had a 2010 battery that was dropped on her.
Does the state have a recommendation as to bond?
The state recommends $5,000. No victim hotline.
And Your Honor, we're asking if the court will consider setting a $1,000 bond. She currently has she's been here 13 years. She has an 8-year-old child at home. She lives with her mom. She indicated she was at home at the listed residence when she was picked up on this case. She wasn't aware that a warrant was out for her arrest. And so $1,000 is something that her family would be able to afford. The $5,000 would be tantamount to no bond for her.
All right, I'm going to set bond in the amount of $5,000 for contact directly or indirectly with the listed victim. Katie Gamet Clark. Are you here for a violation of probation on a felony? You're being held no bond. Your next court date is June 16th at 8:30.
And just for the record, Your Honor, she declined to serve at the public defender's office and indicated she has a private attorney.
Okay. All right, Miss Edmond, you're here for...
No, that's not Miss Edmond.
I'm sorry. Release Edmond.
Is that Miss Gamick? You're being held no bond on a violation of probation. Your court date is on June 16th before your judge, Judge Porter.
DOC was June 17th.
June 16th. That's what he just said. June 16th.
Your court date is June 16th at 8:30, ma'am, before Judge Porter.
Thank you.
All right, release Edmond.
Judge, I'm going to argue no PC is to count one. They're charging her with a robbery, no firearm weapon. I believe that's a second-degree felony. The items were already taken in the court. I believe the statute 812.13 says in the course of taking they use violence. The items in here are. I know it's an academic issue because she's being held no bond on other charges, but I would argue no PC is to count one.
What's the state's response?
Judge, she took the items from the store. The person who was trying to get them back was the owner of the store, and she did use violence, so I would argue that there is PC.
The items were already taken. It wasn't that she took the items from the person or on their person.
Wow. It comes back.
All right. Well, I'm going to find probable cause, and I'm going to set bond on the robbery charge.
Still dressing.
She have priors?
She does. She has a 2013 DWLS, a 2014 petty theft, and she has a pending possession of cannabis and pyrrolidinolethramine in front of Judge Porter. It's set for June 23rd.
Thank you. All right, I'm going to set bond in the amount of $3,000 on count one. And then you're also on counts 2, 3, 4, and 5. You have capiases on all of those charges.
Excuse me, miss.
No bond on count 2. Bond has been set in the amount of $500 on count 3. No bond on count 4, 5. And bond has been set in the amount of $500 on count 6. Your next court date will be June 17th at 2.
Can you tell me if Thomas Heath has been hurt?
Thomas Heath?
H-E-A-T-H.
Michelle Otto.
North Broward, Your Honor.
All right, you're being charged with delivery of PVP within 1,000 feet of a school and also possession of cannabis 20 grams or less. I do find probable cause. Bond has been set in the amount of $5,000 on count 1.
Judge, and just so the court's aware, she has a pending possession of a controlled substance in front of Judge Marion.
Pending?
Yes.
Has the case been filed?
What's the charge?
It's a possession of a controlled substance.
All right, what's the case number?
152968 CF10A.
Is the case filed?
It is.
It's filed?
Yes.
Okay, I'm going to revoke her release on that case number. Would you give me an order to that effect? She's going to be held no bond on that case number as well.
Yes.
152968 CF10A.
Tina Davis.
North Broward, Your Honor. Stand on the X.
Are you here for a violation of probation on a felony charge for which you're being held no bond? Your next court date is June 16th at 8:30.
Okay. Can I explain to her about me?
No.
Jacqueline Milhome.
Name Jill.
All right, you're here for a DUI, alcohol, or drugs first offense and a violation of probation on a felony. I do find probable cause. Bond has been set on the DUI, the amount of $500. No bond for the violation of probation. And I don't have a future court date to give you, but I would imagine you're probably going to get a court date next week.
How much do you get?
Michelle Wilson. All right, you're here for robbery, no firearm or weapon, touch or strike battery, and tampering in a second-degree felony proceeding. Does the defendant have priors?
She does. She has a 2009 possession of cannabis, and she has a pending burglary and petty theft in front of Judge Porter.
And that's a file case?
It is.
Joseph, come in.
What's the case number?
153391 CF10A.
Okay, I'm going to revoke her release on that case number. Does the state have a recommendation as to setting a bond on the robbery charge? And also the tampering.
The state would request a $5,000 bond.
And Your Honor, just for the record, she declined the services of the public defender's office.
Okay, thank you. All right, on the robbery charge, count one, I'm going to set bond in the amount of $5,000. And on the tampering in a second-degree felony proceeding, I'm going to set bond on that matter in the amount of $5,000. Madison Nichols.
Judge, I'm not going to argue PC.
North Broward, Your Honor.
Judge, I'm not going to argue PC. If she doesn't have significant priors, will the court consider her an ROR?
All right, ma'am, you're here for perjury in an official proceeding. I do find probable cause. Does the defendant have any priors?
She has a 2012 possession of cannabis.
All right, ma'am, your bond is set in the amount of $1,000.
Okay.
How long have you lived here?
About 8 years.
Where'd you live before that?
West Virginia.
Who's going to help bond you out?
My grandmother.
Can she afford the $1,000?
Yeah.
All right, your bond's set in the amount of $1,000. Alma Griffin.
Paul Ryan, Your Honor.
Good morning. Here for 2 counts of illegal use of a credit card, and count 3 of resisting an officer without violence, and a case on a misdemeanor charge, for which the bond has been set in the amount of $500. I do find probable cause. Count 1, the bond is set in the amount of $1,000. Count 2, $1,000. Count 3, $100. And as I said, count 4 is $500.
Okay. Okay, talk.
Yes.
Your Honor, can I please be RO'd? I mean, my brother was just killed, and we have to make arrangements for his burial and everything else. And I haven't been arrested in over 5 years.
She was a medical reset for the last 2 days. She pre-trial. I don't know.
We did? Did I let him know? What was the, what did I do with it? I'm sorry, what did you say the priors were again?
She has a 2002 operating without a valid license withhold, and she has a 2002 delivery of cocaine, resisting without violence, and another count of delivery of cocaine. They were all withholds.
All right, you're gonna have to postpone. You're gonna have to postpone.
What you say?
You have to post bond.
It was 10,000?
Okay, there's no way.
Okay, all right. All right, Amanda Garrison.
Paul Ryan, Your Honor.
All right, you're here for a drug paraphernalia charge, 2 KPSs on felony cases, a warrant for 2 warrants for violations of pretrial release on 2 felony cases as well. You have no bond holds on 4 of your charges. You do find probable cause to detain you as to the drug paraphernalia charge, and bond has been set in the amount of $100. Your next court date for the violations of pretrial release and for the KPS on the felony charges is June 14th. Is it 14th? 14th at 2 p.m.
Thank you.
Melissa Barrios.
Paul Ryan again, Your Honor.
Melissa Barrios.
Yes.
Sir? All right, ma'am, you're here for 2 counts of grand theft, a 3rd count of petty theft, and a probation or community control violation for which you're being held no bond. I do find probable cause. Bond has been set in the amount of $2,000 total on counts 1 and 2. And I don't have a future court date to give you as to the violation of probation, but I would imagine you're going to see your judge next week.
Okay.
Sugar Maximus.
Good morning, Your Honor.
Conti, Your Honor.
Good morning, Your Honor. Yes,
You're here
ma'am.
for KPS on a misdemeanor traffic criminal charge. Your bond has been set in the amount of $250.
Yes, ma'am. Ma'am, I've been in 80 days. I've been in like incarcerated by 80 days. I've been placed on probation yesterday. I would like to know, could I work this out, Your Honor? I can't afford the
What
bond.
criminal charge is? What is it?
Possession of cocaine.
Did you just get sentenced for to probation just recently?
Yes, ma'am. Yes, sir.
So this is the only thing that's holding you, right?
Yes, sir.
Will the court consider working this out, Judge? He's
What's the state's offer to resolve this? It's operating without a DO?
1 second, Judge.
Yes, it is true.
Okay. So it wouldn't cause him to be habitualized, right?
no, not with an operating without a valid DL.
All right.
How much probation you get?
I got 3 years, sir.
Okay.
For what charge?
Possession of cocaine.
Possession of cocaine. I've been in 80 days.
Oh, okay.
The state would offer time served.
All right. All right, sir, I would adjudicate you guilty, sentence you to time served if you want to resolve it.
Yes, ma'am.
All right, raise your right hand. Swear
Yes,
to
ma'am.
tell the truth, the whole truth, nothing but the truth.
Yes, ma'am.
Place your hand down. State your name for the record.
Sugar Ray Maximus.
How do you want to plead to this charge?
Guilty.
All right, and when adjudicate you guilty, sentence you to time served, order you to pay court costs. You're done.
Yes, ma'am.
Good luck to you.
Yes, ma'am.
Robert Wetzig.
Thank you.
Robert Wetzig.
He's approaching the main jail.
Okay. All right, sir.
Good morning, Your
Two cases on 2 misdemeanor.
Are you on probation for anything?
No.
I don't
The
bond
bond has
patrol.
been set in the amount of $250 total. Your next court date is June 18th at 2:30.
Judge, will the court consider? I can represent him on count 1, but count 2 is a municipal ordinance.
I
read county ordinance.
The state still represents the state.
No, I said I could do count 1. Oh, okay.
He's indicating yes for count 1, the 2012 open container, that he was time served on that
I
case
did 10 days.
back in 2012.
All right. Does the state have an offer for him to resolve these? Apparently not, because there's a capias out on you for that.
Maybe if we could reset it for the afternoon, because I don't think we can handle count 2 without counsel present. I can look into that
All right,
matter.
let's reset this for this afternoon, okay?
MO.
For the city prosecutor to come in. If you want to resolve this afternoon, if they have an offer to give you, we might be able to take care of it this afternoon. Okay.
Can we get a photo order for him as well?
Yes.
No?
If he resolves both of those cases, then there won't be.
Is there something else holding?
No, there's a MO and then the open container county ordinance. So
Why would they want a photo order on that?
No, I'm just saying if he resolves the case, there's no need for a photo order.
I know, but there must be something else holding him if they want a photo order.
Is there anything else holding him? Do you know?
No, those are the only two.
Okay.
We no longer need you, sir. Have a seat outside.
Black eye and abundance of caution. I understand why she asked for a photo order.
All right, I thought there was another case holding him that they. All right, Zane Thompson Henry. All right, you're here for a KP's on a traffic criminal charge. Bond has been set in the amount of $500.
All right.
Mark Norris. Are you here for trespassing an occupied structure or conveyance? I do find probable cause. Bond has been set in the amount of $100.
Your Honor, he wants to know if the court will consider resolving this.
State have an offer?
Say what offer time, sir.
All right, if he wants to plead no contest, so I adjudicate him guilty, sentence him to time served. Does he want to resolve it?
Yes, Your Honor.
All right, raise your right hand. Swear firm, tell the truth, the whole truth, nothing but the truth. Yes?
Yes.
All right, place your hand down. State your name for the record.
Yes.
State your name for the
Mark
record.
Norris. Mark Norris.
Okay. Do you wish to plead no contest to this charge?
Have any children?
No. Yes.
All right, adjudicate you guilty, sentence you to time served, court costs.
Okay. Thank you.
Percy Campbell. Mr. Campbell, you're here for a violation of probation on a misdemeanor charge. You're being held no bond. Your next court date is June 18th at 10 a.m. Mr. Silver, did you want to call a case?
Sure, Judge. Good morning. How are you?
Before we move on, Campbell, just so the court's aware, he does have another pending case. It's a possession of a firearm by a convicted felon in front of the fraud.
Okay. All right. Well, he's got no bond hold on the VOP anyways. Okay. Which case do you have?
I have Paul Maimon, M-A-I-M-O-N. Brian Silver here on his behalf. And
which jail is he in? You know what page?
Oh, I don't know, Judge. It's a warrant for Berg occupied. And today is a temporary appearance for the time being.
Your Honor?
Don't talk.
Just 1 minute. Just 1 minute. We're getting your paperwork.
It's on page 26.
26.
North Broward.
Said he's in North Broward? Okay. Paul Maimon.
Yes, Your Honor.
Sir, you're here this morning for burglary of an unoccupied dwelling unarmed and a second count of grand theft. You're being held no bond on the first charge, and your bond has been set in the amount of $5,000 on the second count. I do find probable cause. Why is he being held no bond on the burglary? Okay. So he is entitled to a bond, correct?
Yes.
Yeah.
His car, he was arrested in 2010 for burglary on occupied conveyance that was dropped. In 2011, he received a withhold on possession of marijuana. He was arrested for battery. He went through some kind of big trial. I saw that to be all lost. Arrested. That was drunk. I just saw 2014 also drunk. He was arrested January of this year in aggravated battery with a weapon that appears to be open and pending.
That's in Palm Beach?
Yes.
Okay. All right, Mr. Silver?
Judge, we're asking you to set the standard bond.
What's the standard bond for a burg dwelling?
There's no standard bond.
Yeah, because you have to have a hearing.
There used to, but not anymore.
What did it used to be?
3,500 for unoccupied, 35 for unoccupied, 5 for unoccupied, 5,000.
So then I would ask the court to set bond as to count one in the amount of $5,000.
Okay. All right. All right, sir, I'm going to set your bond on count one, amount of $5,000. It's already been set at $5,000 on count two, so your total bond amount is $10,000.
Thank you, Judge.
Thank you.
Thank you.
Does the PD have a PC affidavit?
Yeah, I can.
Sure.
And you want to give this goes in the court file, right? Okay. Paul Acevedo. All right, Mr. Acevedo, we're here this morning for one count of petty theft, second degree. I do find probable cause. Bond is set at $25.
Judge, he has a pending DUI in front of Judge Diaz.
Mr. Central?
Okay. All right, sir, since you're already out under supervision with pretrial release and you picked up a new law violation, I'm going to revoke your release status. You since on a DUI? Yeah. Okay. All right.
Hey, would you consider setting a monetary bond on
You
that
can go in front of
case?
Judge Diaz and he can determine the appropriate bond amount.
Thank you.
Melvin Davis. All right, sir, you're charged with failure to register a motor vehicle, operating without a valid driver's license, failure to provide proof of liability security, and also a fourth violation of probation on a misdemeanor charge. The bond on the violation is set in the amount of $5,000. And I do find probable cause as to count one. Bond has been set in that matter in the amount of $25.
Judge, he also has another pending operating without a valid license in front of Judge Levy Cohen.
Right.
Just the court does have discretion. I would ask the court not to revoke his release. Thank you.
Your Honor, he's supposed to hear on a case that was already called and there was...
Okay, which one? I'm sorry.
No problem. Thank you, Your Honor. They're here on Thomas Heath. It was a domestic violence case.
Okay.
They released him on his own recognizance, but he ordered no contact and they wanted to address you briefly.
Okay, all right. You want to come up to the podium? All right, you want to raise your right hand? Swear firm, tell the truth, the whole truth, nothing but the truth.
Yes.
Okay, place your hand down. Please state your name for the record.
Richard Vanais, V-A-N-N-A-I-S.
Okay. And this was which defendant again? Mr. Heath?
Thomas Heath.
Can I see the paperwork of Mr. Heath?
I'm sorry, Your Honor. What defendant are we on?
We're going back to a domestic charge that I already handled, where we have family members present in the courtroom. Mr. Heath.
Okay.
Mr. Heath.
Okay.
Probably not there anymore.
Thank you.
Okay. Go ahead and state your name again for the record.
Richard Vanais,
Okay, and what's your relationship to Mr. Heath?
stepfather.
All right. And what would you like to tell me, sir? You are the listed victim in the case, correct?
Yes.
Okay, what would you like to tell me?
There was an altercation at our home yesterday, and the police were called, and there was a little scuffle, and I told the police, and he told the police, we both didn't want to press charges, but they took it upon themselves, as is the right, to place charges on him because they didn't want him in the home. But I do not fear for my safety, and having him, because you have ruled that he has no contact with me, having him to find alternate living arrangements would be a great hardship on the young man, and we would like to have him
live for a few days?
I would like to have him back in the home. I have no fear for him.
Has he ever been violent towards you in the past?
Well, I mean, physical contact, but no punching or anything like that. Nothing
What's the
before.
difference?
What's the difference?
Yeah, between physical contact and...
Well, you were.
Same
I'm
thing?
sorry. I don't mean to argue with you. It was physical contact. Yes. Physical violence. No.
What do you mean by physical contact? Pushing and shoving?
Push. Yeah.
Okay. And And how many times has that happened?
A couple times.
Would you be in fear for your safety if I were to permit contact with him?
Absolutely not.
You know, I'm just concerned, even though you said he's not been violent, but there's been physical contact, pushing and shoving. There's obviously some issue that's not been resolved between you two, and it's just escalating.
Yeah.
So,
And that may be a part.
To this
That
case
may be a part of the package that he needs to go to, and I've heard mention of the word resolve here. He may have some mental health issues, and they may need to be addressed. He's been undiagnosed, and I think they're not so bad that medication may in fact not be of great help to the man. But it would be a great hardship on him and his mother and myself if he were caused to live at some other location, even for a short time. He's got a job which he's been holding and doing very well, and the people at his workplace like him very much.
I think at this point, I'm going to leave it as a no contact order because I'm concerned that it appears that the level of violence is increasing from pushing and now it's punching. What you can do is you can call my office. You can set up a hearing to modify the no contact order, which we can get you in next week, probably a week from, I don't know if we're going to be able to do it on Monday, but probably next Thursday.
How long with the no contact order?
I do think you need to be separated for a while. Both of you need to be separated for a while.
Do you have some sort of time frame on that?
The time frame would probably be, what's a week from Thursday? What's next Thursday? What day is that? 18th?
Yes.
Okay. All right, you can call my office. You could set up a court date for the following Thursday for a motion to modify the no contact order. But I think that you two need to be separated. I don't know what the issues are between you, but apparently there's some unresolved conflict between you, and I think there needs to be a cooling off period.
Okay.
Okay, so he's going to have to find alternative living arrangements until then.
I understand that.
Okay? All right.
I'm
Thank
his
you.
mother, and I have his bank card. He won't have any access to his money.
Okay, well, he's permitted to have contact with you.
But we live in the same house.
I know. I ROR'd him. He's released on his own recognizance. I didn't.
So I
not even
can meet
making
him somewhere, you mean?
Yeah, he's going to be released today. I
Okay.
didn't even make him post a bond because
Okay.
he's never been in trouble
Okay.
before.
Yeah, he's
right.
never been.
Right.
Never.
So I released him on his
And
own
that's the same.
recognizance.
Okay,
So he should be released sometime in the afternoon, I would
okay,
imagine.
okay,
Okay?
thank you.
But I
Is
just
there-
want- if he has a friend or other family member he can live with in the meantime, fine. But I just think there needs to be some separation and a cooling off period.
Okay.
Call my office, set up a hearing to modify the no contact order, and I'd be happy to hear it then.
Okay.
Okay?
Thank you.
All right, thank you. Thank you. I'll see you next week, most
Okay.
likely. Okay.
We're done.
Okay.
Jose Enriquez.
Is this yours?
Thank you.
All right, thank you, sir. Thank you.
Thank you.
All right, Mr. Enriquez, you're for great use of the traffic charge. Bond has been set in the amount of $250.
Will the court consider working this out if he wants to work it out?
Does he want to bond out?
Your Honor, he's interested in the court's offer.
All right.
Your Honor has
Well, I
one.
don't know the offer because I don't know what his record is. Does he have priors? Actually, does the state have an offer? Looking
One
at his
second,
priors.
Judge.
This is Jose Enriquez.
Yes.
Bond was posted.
Oh, bond's already been posted.
All right.
Donald Biancoli.
North Broward, Your Honor.
All right, sir, you're here for resisting an officer without violence and second count of trespass on property.
Can,
By probable cause, bond has been set in the amount of $100.
Judge, may I inquire if he wants to work it out, and if the court is so inclined, maybe there can be an offer. Sir, do you want to work this case out today, or you want to? You can fight your case. The state has to prove these charges beyond a reasonable doubt. Or if you want to resolve this case, I can ask the court to convey an offer.
Yeah, I want to resolve it.
You know what, though, on a resisting without charge, you can't resolve it because it's not been filed. You can't resolve a case that's not been filed.
Oh, I thought. Okay.
All right, your bond is set in the amount of $100. Matt Anderson. Sir, you're here for 2 misdemeanor capiases on 2 misdemeanor ordinance violations. We're going to reschedule this for this afternoon. Your bond has been set in the total amount of $100 each. So we're going to reset it for the afternoon for the city prosecutor to be here and for counsel. Eric McGowan.
Main jail?
All right, so you're charged with trespass, failure to leave property. Bond has been set in the amount of $25. I do find probable cause.
Your Honor, would you consider resolving this case?
Let me ask you this, I mean, if these are unfiled charges, it's a state statute.
And trespasses all the time.
I know, but still, I mean, they're state statutes, and how do you resolve them when they're not even filed?
It's a municipal ordinance.
Right? It's not charged as an MO. Right? State's got to make a filing decision on this, right? So, bond has been set in the amount of $25.
Your Honor, would you consider releasing him on his own recognizance?
Does he have priors?
He does. He has a 2015 failure to register and operating without a valid license, 2012 resisting without violence and unlawful possession of a driver's license, 2011 grand theft and uttering a forced instrument, 2 counts of each, another 2011 grand theft, 2011 failure to register, 2008 possession of cannabis, and a 2007 expired driver's license.
No, he's going to have to post a bond. Devontae Nelson.
He's approaching.
Don't worry about it. You're charged with a capias on a felony charge. Held in a bond. Your next court date is June 16th at 8:30. Ashikin Tarzan.
County, Your Honor. Hi, Your Honor.
That's cool. All right, so you're here for a capias on a felony charge. The bond has been set in the amount of $1,000.
Your Honor, I have a question.
Yes, sir.
I have a job and I have school on the outside. Is there any way I could be eligible for pre-child?
Does he have priors?
What's your bond amount on count 1 and 2?
I don't know.
What do you know his bond?
Devontae,
No, this is Ashkan Harzan.
But I haven't been convicted of a felony, so.
Okay, he has a VOP.
All right, sir, you're going to go to court June 16th at 8:30.
All right, Your Honor.
Julius Reyes.
He's at court, Your Honor.
Yeah, because he's in court. I guess we're set for Monday? Or this afternoon?
Tomorrow.
Tomorrow, Saturday? Okay.
Yeah, yes.
All right, that's right. Ira Tyson. All right, you're here for a capias on a felony charge. Bond has been set in the amount of $1,000. Your next court date is June 16th at 8:30. Gavin Jacoupy. All right, sir, you're charged with 8 counts. Count 1 is burg dwelling while armed. Count 2 is petty theft. Count 3 is criminal attempt or solicitation. Count 4 is ag assault with a deadly weapon without intent. Count 5 is burglary with an assault or battery. Count 6 is petty theft. Count 7 is criminal attempt. Count 8 is burglary of an unoccupied dwelling unarmed.
Judge, we addressed count 1 yesterday. You found no PC as to the armed burglary. I would ask the court to, and you set a bond for $10,000 on count 1. Right. Mr. Linder informed me yesterday and also informed the court that there were ad charges there, and they provided supplements.
Okay.
So if the court's going to count 5 with regards to Mr. Jacoupy and Mr.
That's burglary with an assault?
Yeah.
Those are the ad charges.
Those are the ad. I think they only ad charged Mr. Jacoupy with burglary with assault. The co-defendant wasn't charged with the burglary with the assault.
All right. Okay.
So in order for the court to hold him no bond as to count 5, the court has to make a finding that proof evident presumption grade.
Okay, which I have reviewed the information in regards to that count, and I do find proof of guilt is evident, presumption is great, and he will be held no bond on that count.
Consider exercising discretion. I understand.
No, he can go in front of the judge assigned to the case and request setting the bond. Does the state have a recommendation for the bond amount for count 5? And
They would be asking for a $10,000 bond.
I'm sorry?
The 4 and 8?
4 and 8, yeah.
$10,000 on each, Judge.
All right, on count 4, I'm going to set bond in the amount of $5,000, and count 8, I'm going to set that in the amount of $5,000. Got substantial bonds on the other charges and no bond holds as well. All right. Adam Alchin. All right, sir, you're charged as a co-defendant with burglary, dwelling structure, or conveyance while armed. I did not find PC yesterday on that one, and I set bond in the amount of $10,000. Also, second count of petty theft. Count 3, criminal attempt or solicitation. Count 4, your bond was surrendered on a felony charge. And count 5 is burglary of unoccupied dwelling unarmed, for which we need a hearing, which we kind of already had the hearing yesterday. State have a recommendation for setting a bond on count 5.
One second, Judge. They would ask for a $5,000 bond.
I'm going to set bond on count 5 in the amount of $5,000. David Tejeda. All right, sir, you're charged with count 1, grand theft, count 2, grand theft, count 3, fraudulent uttering of a false instrument, and count 4, grand theft. I do find probable cause as to each count. Your total bond amount is $4,000.
Okay, we're done.
Khalil Tyndall. All right, you're charged with count 1, grand theft, count 2, touch or strike battery, count 3, touch or strike battery, and count 4 is an out-of-state hold on a felony. Which you're being held no bond.
Thank you very much.
I do find probable cause. This is counts 1, 2, and 3. Your bonds on 1, 2, or 3 are a total amount of $3,000. Lorenzo Coleman.
Yes, ma'am. North Broward, Your Honor.
All right, Mr. Coleman, you're here for 2 felony violations of probation for which you're being held no bond. Your next court date is June 16th at 8:45.
All right.
Jason Centrone.
Woman.
Main jail?
Okay, so count one should be what?
Count one was changed to possession of alprazolam.
Okay.
They gave an accidentally 2 counts of methamphetamine. We corrected it.
All right, so count one is the alprazolam. ALPRAZ. All right, sir, you're here this morning for 1 count of possession of alprazolam. Count 2 is possession of methamphetamine. Count 3 is drug paraphernalia, and count 4 is loitering and prowling. I do find probable cause. Bond is set in the amount of 1,000 on count 1, 1,000 on count 2, 100 on count 3, and 25 on count 4. Michael Roberts. All right.
North Broward, Your Honor.
All right, you're here this morning for possession of PVP. I do find probable cause. Bond has been set in the amount of $1,000.
Judge, would the court consider pretrial release due to the nonviolent nature of the offense?
Does he have priors?
Judge, may I just briefly inquire?
Okay.
Sir, do you have a place to stay?
No. But I could contact my father, and I could go stay with my father if needed.
What? Who's going to help bond you out?
I don't have nobody.
It's possession of meth, 2014. And domestic violence battery from February this year that was dropped.
Okay. All right, sir, you're going to have to post bond. All right, we have the interpreter here. On Joan San Pedro Ortega. All right, you're here this morning in regards to an aggravated assault.
Está usted aquí sobre lo que es un asalto con agravantes con un arma mortífera
Information violation.
y una violación de la probatoria libertad condicional.
Does the defendant have any prior criminal history?
¿Tiene alguna historia, antecedentes penales anteriores?
This is San Pedro Ortega.
No entendí. San Pedro Ortega.
Sí.
Agresión, arrestado por agresión. No se procedió judicialmente en ese caso. 2009. Agresión doméstica, no se procedió. 14. Robo mayor cuantía, fallo no condenatorio.
Okay, State have a recommendation for bond.
Recomendación para la fianza, fiscalía.
The state will recommend $10,000.
Recomendamos $10,000 de fianza.
All right, sir, I do find probable
Señor,
cause
encuentro
on
que
count
si
one,
existe
I'm
el
gonna set
cargo
bond in the amount
probable,
of $10,000.
le voy a poner la fianza en $10,000.
Also being held no bond.
También se le sostiene con no fianza
Violation of probation.
en la violación de lo que es su probatoria.
And your next court date is June 16th
Y junio 16 es su próxima fecha de tribunal,
at 9 a.m.
a las 9 de la mañana.
Oh, also, you're not to have any direct or
También
indirect contact
no
with
puede
the listed
tener
victim.
contacto ni directo ni indirecto con la víctima en la lista.
If you're released on that charge,
Si se le deja en libertad en esa acusación, no puede poseer ningún arma
surrender
ni
to your local
munición.
police department.
Cualquier cosa que tenga de arma se lo debe regresar a la policía.
All right, thank you, Madam Interpreter. Would you make an announcement to everybody else there whether they need your services?
¿Alguien más necesita intérprete en español?
All right. Hearing nothing, thank you so much and have a great weekend.
Yes. Thank you, Your Honor.
Alexa Jenkins. All right, you're here for possession of PVP and a probation violation. I do find probable cause on the PVP. Bond set in the amount of $1,000. You're being held no bond on the probation violation. Your next court date's June 14th at 8:45. Is that 14th or no? 17th? June 17th at 8:45. Jimmy DeBrew.
One moment, Your Honor. He's approaching.
Okay.
Judge, I don't think there's enough as to count one aggravated assault on law enforcement officer. It seems that he was already in custody. I think most they have is a criminal mischief.
Okay. All right, count one is an aggravated assault on an officer or firefighter. Count 2 and 3 are resisting count 2 is resisting with violence. Count 3 is resisting without violence. Count 4 is driving while license suspended. Count 5 is unlawful speed posted. Count 6 is failure to use due care. What's the state's argument as to count 1? No PC.
Judge, I think it's obvious the defendant was swinging his arms around, and that's when he hit the officer. So I would argue that there is PCS to count 1.
He hit the officers. They charged him with resist with violence.
Say 1 time to perfect. That?
Sure, Judge.
Okay, I'll give you 24 hours to perfect on count 1. The resisting officer with violence, I do find probable cause as to that. Does he have priors?
The defendant is actually out on 14-14078.
What's that charge?
For 14-14078, possession of cocaine and intent to deliver.
Is it filed?
Okay, so 14.
Let me get again 14.
14078. And then he has a 14-9444. 14-9441 MM10. That's also open. That's disorderly and DUI.
What was the charge on the felony? That's open?
The charge on the felony is possession of cocaine.
Okay, all right.
With intent to deliver.
All right, I'm going to revoke his release on that charge.
It's in front of the court.
Okay, I'm going to revoke his release on that charge. Set bond on the resisting with violence in the amount of $2,000. Bond on the resisting without violence is $100. Driving while license suspended, the bond is $750. And no applicable bonds. And then we're going to have a perfection hearing tomorrow on the aggravated assault on the officer. Okay, John Thompson, and I need an order on revoking his release on the cocaine charge. John Thompson, you're here for... Is this Mr. Thompson? Okay.
North Broward, Your Honor.
All right. You're here for 5 counts. You're here for possession with intent to sell, deliver alprazolam within 1,000 place of worship.
That's a lie. I wasn't delivering anything, Your Honor.
All right. Well, don't talk about the facts. Count 2 is same possession with intent to sell or deliver amphetamine within 1,000 feet of a place of worship. Count 3, possession with intent to sell, manufacture, deliver cannabis within 1,000 feet of a place of worship. Count 4 is trafficking in oxycodone. Count 5 is possession with intent to sell, manufacture, deliver heroin within 1,000 feet of a place of worship. All right. I do find probable cause. Bond is set in the amount of $5,000 on count 1, $5,000 on count 2, $5,000 on count 3, $75,000 on count 4, and $7,500 on count 5.
Judge, may I just inquire as to his ties? Count 4 is $75,000. Sir, how long? So, do you have a place to stay?
Yes, sir.
Okay. How long have you been living? Go ahead.
My mom's in the hospital right now, and the officer told me to leave, and then he just stopped me. I don't understand what's going on.
Okay. Let's not talk about the facts of the case, but right now your bond is.
I don't have it. I don't have any. They took my money also, so I don't know what
Okay,
I'm gonna do.
what about, do you have anybody to help bond you out? I mean, how much can you afford?
I can't afford anything. They took the last of what I had. They took $240 from me. Like I don't even know what to do.
There's priors of drug charges, from March this year to out of date.
I'm not reducing that bond. He's been in the possession of 5 different drugs: alprazolam, amphetamine, cannabis, oxycodone, and heroin.
Okay, but ma'am,
Post
I
a bond,
wasn't.
sir.
I wasn't there.
Vincent
I was there.
Patterson.
When's my next court date?
Are you here for violation of community control on a felony? Being held no bond, and your next court date is June 16th at 9 a.m. Jacoby Mays. Jacoby Mays. All right, you're here for a violation of probation on a felony. You're being held no bond. Your next court date is June 16th at 9 a.m. Darren DeVoe. Here for a violation of probation on a felony. You're being held no bond. Your next court date is June 16th at 8:45. Theodore Mara.
He's in regular court, Your Honor.
Yeah, he's in regular court.
Your Honor, did you call Vincent Patterson on page 25?
Yeah, we called him. Yes. Yes, we did.
Okay.
Okay. Thanks. All right, Mr. Banks, you're charged with delivering PVP within 1,000 feet of a school,
Judge,
community center, or a park. Possession with intent to sell, manufacture, deliver PVP within 1,000 feet of a school, and also a writ of arrest. Yes, Counsel.
Judge, with regards to the intent to sell, it seems like a conclusory statement. Was within 1,000 feet. Did they measure how far it was? Did they? I'm not familiar with the address of the arrest and how far it is from Shanahan Park, but I would argue there's only PC with possession with intent to deliver PVP.
State what's your argument.
The state would ask for time of effect.
Okay. All right, I found no PC. I'll give the state 24 hours to perfect the distance to the school, community center, or park as to those 2 charges. And but sir, at this point, your bond has been set in the amount of $5,000 on count 1, $5,000 on count 2, and $400 on the writ of arrest.
Your Honor, would you consider reducing his bond on count 1 and 2? He's
So we
been
have a perfection hearing.
Okay.
Kamaine Joseph. All right, sir, you're here for petty theft and for a probation violation. I do find probable cause. Bond has been set in the amount of $25 on the petty theft charge. Being held no bond on the probation violation. Your next court date is June 16th at 8:30. Anthony Clark. All right, sir, you're here for burglary of an occupied dwelling unarmed. Does the defendant have priors?
No priors, Your Honor.
All right, I do find probable cause. Public defender want to add anything?
Yes, Your Honor. He's been in South Florida all of his life. He indicates that he's currently a drummer at Jesus People's Church, and he also works part-time at his sister's restaurant. If a bond is set, he's asking if the court will consider setting a $1,000 bond, or if Your Honor would consider ROR with pretrial release. He does have a stable address to reside. All of his family lives here in South Florida.
All right, I'm going to set bond in this matter in the amount of $3,000. Travis Eckstein. Right, sir, you're here for possession of alprazolam and possession of cannabis. I do find probable cause. Bond is set in the amount of $1,000. Jeffrey Jordan. Jordan, you're here for possession of PVP, possession of cannabis, 20 grams or less. I do find probable cause. Bond has been set in the amount of $1,000. Deontre Clark.
Judge, same issue with regards to count one. It seems like it's the same location, Stranahan Park, as previous one of the previous cases. He may be in a co-defendant, but I would argue no PC. That's to count one within 1,000 feet of a school park. It just, he makes a statement it's within 1,000 feet, but there's nothing supporting that they.
State one time to perfect.
Please.
All right, 24 hours to perfect. Sir, I don't find probable cause as to the delivery of PVP within 1,000 feet of a school, community center, or park. I'm going to give the state 24 hours to perfect that. I do find probable cause for possession of cocaine and drug paraphernalia. At this point, your bond on count one is set in the amount of $5,000, count two, $1,000, count three, $100. Be brought back tomorrow for your perfection hearing. Colton Sly. So you're charged with one count of grand theft auto. I do find probable cause. Bond has been set in the amount of $1,000. Bedlin Vile. All right, you're charged with one count of possession of cocaine and a warrant on a misdemeanor charge. I do find probable cause. Bond has been set in the amount of $1,000, and you're being held no bond on the misdemeanor warrant. Tyre Refner. All right, you're charged with possession with intent to sell, manufacture, deliver cannabis, possession of cannabis 25 grams or less, and drug paraphernalia. If you find probable cause, bond is set in the amount of $1,000.
Your Honor, he was arrested 2013 for domestic violence and battery. Was received to disorderly conduct, he was placed on 6 months probation, and after the wait for according to the plans where he's supposed to do shopping spots or
all right, can we get Mr. Refner back? Mr. Refner, do you want to post this bond, or do you want to be supervised by pretrial release with special conditions? You'd have to submit to a drug evaluation, follow any recommendations of that evaluation.
Yes, Your Honor, he'd like to be considered for pretrial release.
All right, I'll release him to standard pretrial.
Thank you.
Lionel Charles. All right, so you're here for a driving while license suspended, third or subsequent offense, expired motor vehicle registration over 6 months, and 2 misdemeanor cases. I do find probable cause. Bond is set on the first count, amount of $750. Bond on count 3 is $500. Count 4, why does it say no bond and then $250? Bond on count 4 is $250. Your next court date is June 19th at 10 a.m. Lamar Clark.
Judge, would the court consider ROR due to the nature of the charges?
Mark Clark. All right, you're here for possession of cannabis, 20 grams. Over 20 grams. Yeah, it's over 20 grams. I do find probable cause. Bond is set in the amount of $1,000. Anthony Speranzo.
Judge, would the court do a mental health screen on Mr. Speranzo?
Is he there? Speranzo.
Your Honor, he's a medical reset.
Medical reset? Okay.
Yes, ma'am.
Okay. All right. Christopher Nicholas. All right, Mr. Nicholas, you're here for a violation of probation on a felony charge. You're being held no bond. Your next court date is June 17th at 8:45. Howard Guthrie. Howard Guthrie. Howard Guthrie.
Medical reset.
Lionel Joseph.
Paul Ryan, Your Honor.
All right, Mr. Joseph, you are here for a criminal mischief charge. Being held no bond. Is he entitled to bond? Take an out charge. Defendant have priors.
1 second.
What's count 1 and 2?
Counts 1 and 2, count 1, burglary, assault, battery, no bond. Count 2, touch, strike, battery, domestic violence, 7,500. And then count 3 was COC, and the bond is to be set at judge.
All right, so this is a criminal mischief now?
The original bond was $1,000 to the criminal mischief.
Okay.
And he does have priors, Judge.
All right.
He has a possession of a controlled
He
substance.
also has count 4, a 940 legal 6 BLP.
The court set a $1,000 bond on count 3.
Yes. All right, sir, your bond is set in the amount of $1,000. Christian Williams. All right, Mr. Williams, you're here for violating drug probation on a felony charge. You're being held no bond. Your next court date is June 15th at 8:30. Anthony Piergrossi.
North Broward, Your Honor.
Sir, you're here on 2 counts of petty theft and a 3rd count of criminal mischief.
The court.
You have probable cause. You've been ROR'd on the first 2 charges. Your bond has been set in the amount of $500 on the 3rd charge.
Will the court ROR on count 3, Judge?
Do you have priors?
He's been reset for.
Burglaries, unoccupied conveyance, went to prison, was released in 2013. Loiter and prowling, and another burg structure adjudication.
All right, he's gonna have to post a bond. Bond's $500, sir. Tyrone Dixon.
Counsel, Your Honor. Good morning, Your Honor.
Good morning, sir.
How you doing?
I'm doing great.
Okay.
All right, you're here this morning for a burg dwelling structure or conveyance while armed and a possession
Yes,
of a
ma'am.
controlled substance without a prescription.
Yes, ma'am.
What happened? You didn't do this. Tyrone Dixon.
Your Honor?
Just 1 second.
Okay.
He armed himself with an unknown weapon. Inside the residence. So I have questions concerning probable cause. It says he was in possession of an unknown weapon. I don't know if that's sufficient for probable cause. Defense?
I would reiterate, I would agree with the court. I would ask the court to find no PC and ROR.
Yes, Judge.
All right, I'll give the state 24 hours to perfect. At this point, sir, you held no bond on count 1. You find probable cause as to count 2. Bond's been set in the amount of $1,000. But we're going to have I'm going to give the state 24 hours to perfect the armed component of this, because the police report indicates you were in the possession of an unknown weapon, and I don't know that that's sufficient to establish probable cause.
Okay, Your Honor.
For this charge.
My second.
Hold on 1 second. State.
Yeah, it looks like probable cause was already found. That's why I'm a little confused.
When? Yeah, 'cause he's been in the hospital.
He's been in the hospital.
Right, but we could have. Yeah, you doesn't have to have.
Arguing he doesn't rise to rule proof evident presumption. Great.
It's been a medical reset. All right, we're going to bring you back tomorrow, sir. It's not going to be me doing magistrates tomorrow. It's going to be another judge. But I just have concerns about an unknown weapon.
My second magistrate, they had like 40, like another some amount of hours to do it, to find it, and they didn't find it. Whatever they were supposed to find it, because I wasn't on with no type of whatever. And this is my third magistrate.
Is the first time you the first time you've been on video?
This is my third time, ma'am.
Yeah, I showed your business, the probable cause was found, you're the finding order.
When? What was the date?
What date? The 6th?
8:15. It says McHugh.
McHugh found it. He set up a $5,000 bond on 1 and a $1,000 on 2.
I can't post no bond. I have I ain't got no job, no money.
He might have not found PC. So. Okay.
I don't know. The bond is set aside. Do you have anything?
Mark was the judge last weekend. Yes. Last Sunday, I think.
Was he here on Saturday or Sunday?
Why would they bring him back today if you already have more PC was already found over the weekend? Well, let me ask you this: if it's armed burg dwelling, if I set a bond of $5,000, then there must have been an issue with probable cause.
Right, it looks like he didn't find PC for the armed, it looks like.
Right.
That's why. Here's one.
So there was no PC found.
For armed.
Okay, all right.
So it's only coming back for the arm.
Oh, so today was supposed to be the perfection hearing. Gotcha, now it makes sense.
Judge, I would ask the court to ROR count 1, unless the state has additional information.
Well, I would find probable cause to burglary, but not armed.
The burg dwelling armed is incorrect.
Right now, is he being held no bond in the sheriff?
No, 5,000. That was yours. Oh, no, this is.
So I gave him 5,000 already, but he was a medical reset all this week, wasn't he?
Yes.
So I probably gave him a $5,000 bond because I probably had concerns about the armed component of this. So at this point, I'm just going to leave it at 5,000. Do I need to write that in there? Sir, your total bond amount is $6,000.
There's no way. I have no job to pay no bond.
All right, well, you need to go in front of the judge assigned to your case and request a bond reduction. Probable cause is found only on burglary. Burgling, not armed. Okay. Right. Okay, Troy Smith.
Your Honor, Mr. Smith is a medical reset.
Okay. Thank you.
You're welcome.
Williams Sands. You bonded? Is that true? Bonded? All right. It's a wrap. And it's 10 after. 11 after.